Well, good afternoon, everyone. I'd like to begin this session by acknowledging the traditional owners of the land on which we meet, the Ngunnawal people, and pay our respects to their elders past, present and future. My name is Cain Sibley. I'm here with Deborah Mak, and it's with pleasure that we welcome you to the first of our online government CLEs. While we abide by physical distancing rules, we have moved our usual monthly government CLEs to an online format so that we can continue to provide our continuous legal education sessions throughout these unprecedented times. We have several more scheduled CLEs for the remainder of the year, so please keep an eye out for these invitations. In today's session, we're going to be talking about materiality in judicial review and how it affects government decision making. What we're going to do is discuss how materiality has been developed and applied by the courts in recent decisions, particularly focusing on the High Court and the full Federal Court, and how it sits within other principles of jurisdictional error and other principles related to judicial review. We're going to have a look at how materiality fits in with other concepts like futility and how both of them involve looking at the way errors in a decision affect the way in which the courts conduct judicial review. Before we start talking about materiality, we thought it would be good to start with a bit of a discussion of some relevant concepts in judicial review to see how materiality fits in with the broader patchwork of principles of judicial review, which really at their heart are about defining the proper role of judicial review. So obviously one of the first starting points is that judicial review is not merits review, and one of the main focuses of courts is to ensure that judicial review stays within its proper bounds and doesn't stray into merits review. And as we all know, the proper role of judicial review is to only intervene if there's been a legal error in the decision-making process. Whether or not the decision was just is beside the point for judicial review. And over time, courts have come up with a number of different ways to try and keep judicial review within those boundaries. One of the main tools that's used by the court is the concept of jurisdictional error, which has been described as one of the weasel sort of words in the law, and also a sort of notoriously slippery concept to grasp. Why jurisdictional error is important is because for a court to grant one of the constitutional writs, an error must go to the jurisdiction of the decision maker. So basically a jurisdictional error will be relevant if you're seeking any relief under Section 75(5) of the Constitution or its analogues in the Judiciary Act in Section 39B. And what jurisdictional error really signifies is that there's been a breach of the legal rules that mark out the limits of a decision maker's power. As we've seen over the past decade or so, practically whether an error is jurisdictional or not will depend on the statutory context and the proper construction of the statutory power that's in question. And courts will look at the legislation as a whole to determine whether it was intended that the error would render the decision invalid. Now, notwithstanding that jurisdictional error is very important in judicial review, it's worth noting that it's not needed for all forms of judicial review. So under the ADGR Act, the grounds of review in the ADGR Act are not dependent on there being a jurisdictional error, and also certiorari still can issue for a non-jurisdictional error on the face of the record. So it's an important feature in judicial review, but it's not the gateway to all judicial review. The courts have struggled to come up with a organising principle for jurisdictional error. It was originally thought as being a standalone ground of review, but over time it's become more accepted that jurisdictional error is a category of legal error that a decision might be infected with. So some common types of errors that give rise to jurisdictional error are, and these come from the case of Craig in South Australia, a fail to accord procedural fairness, legal unreasonableness, misconstruction of the statute or asking the wrong question, not having regard to a relevant matter, apprehended bias, or the absence of a jurisdictional fact. But the concept of jurisdictional error really has become something of a conclusory label. It's a label that a court applies after having found that a decision is infected by an error to signify the seriousness of the error such as to warrant judicial intervention in the decision. Basically, we think that jurisdictional error has become a very subjective concept. With that background in mind, how then does materiality fit into the picture? Basically, since the decisions of the High Court in Hussain and SZMTA, materiality is becoming used by courts to assess whether an error is jurisdictional. And the test of materiality is whether the outcome of an administrative decision would have remained the same even if the legal error had not been made. So in other words, did the error make a difference to the ultimate decision that was reached by the decision maker? If the error would have made no difference, then the error is not material, and if it would have, then the error would be material. So what an applicant for judicial review needs to show is that there is a connection between the error and the decision that was ultimately made by the decision maker. In some ways, materiality doesn't change the essential nature of judicial review. You still have to identify the legal error, and you still need to show, at least in the case of the constitutional writs, that the error is jurisdictional. What's different about materiality is that materiality is, at least for some judges of the High Court, being used as the touchstone of whether or not an error will be jurisdictional. We said in the last administrative law year in review that we presented earlier in the year that materiality seemed to have emerged from nowhere and sort of just cropped up in relatively recent times. And while it's clear we think that it's becoming a much more significant component in judicial review, it has been bubbling under the surface for quite a while, and there's a number of cases going back several decades where the general idea of materiality has been sitting latent, and it's only sort of in more recent times that the High Court has picked it up. So, for example, in the famous case of Pico Wallsend, a case about whether or not a decision maker had taken into account relevant considerations, the High Court said that a factor may be of such little importance that the court may decide that the failure to take it into account could have had no material effect on the decision under review. So, in 1986, the High Court had introduced the idea that a failure to have regard to a relevant consideration may not be material, and therefore that it may not warrant judicial intervention. Likewise, in Lewin, the Minister for Immigration, the federal court reviewed the authorities and referred in particular to ex parte ALA and said that in relation to procedural fairness, an applicant is only entitled to succeed in making out procedural fairness if the denial of procedural fairness had a bearing on the outcome of the decision that was made. So if denying procedural fairness could have had no bearing on the decision that was made, then the error won't warrant judicial intervention. And likewise, in ex parte land, the principle of practical injustice also has its sort of a similar consideration about whether or not the denial of procedural fairness could have had any practical impact on the decision that was ultimately reached. So the concept of materiality has been around for a while and has been bubbling away, but it's come to the fore in a couple of cases. And the first case that I wanted to mention is Hussain and the Minister for Immigration and Border Protection. The facts of this case are that there was an applicant for a partner visa, Mr. Hussain, and there were two relevant criteria that the decision maker found that Mr. Hussain had not satisfied. One of the criterion, one of the criteria that was considered, the applicant and the Minister for Immigration both agreed that the relevant decision maker had misconstrued the test. So they both agreed that the tribunal had asked itself the wrong question about this particular criterion. The tribunal had applied the test at a particular point in time, but the real test was at a later point. So there was no doubt that there was an error in the decision. The difficulty for Mr. Hussain was that there was another criterion which was about outstanding debts and whether or not the decision maker was satisfied that arrangements had been made for payment of outstanding debts. And Mr. Hussain had fallen over on that criterion as well. So the High Court ultimately decided that even though there was an error in the decision, it could have made no difference to the outcome because Mr. Hussain was always going to fail on the second of the statutory criteria. Now, not all, the High Court didn't give a unanimous decision, and there is some differences in the way the court approached the issue. So Chief Justice Kiefel, Justice Gaver and Justice Cain found that in order for an error complained of to be a jurisdictional error, it must have been material to the outcome of the decision. So what their Honour said was that while a statute on its proper construction might set a higher or lower threshold of materiality, the threshold of materiality would not ordinarily be met in the event of a failure to comply with the condition if complying with the condition could have made no difference to the decision that was made. So their Honours found that materiality, was to be equated with jurisdictional error. Justice Neville largely agreed with that analysis, although wasn't prepared to find that an error might not be jurisdictional error, even if it could have made no difference to the outcome. So what was said was that it is odd that basically materiality is a way of identifying whether or the consequences of a decision being jurisdictional rather than as a way to identify whether or not the error is jurisdictional. And so infrequently it will be the case that it will deprive a party of a successful outcome, but left open the possibility that it may not. Similarly, Justice Edelman said that materiality will generally require the error to deprive the person of the possibility of a successful outcome, but there may be unusual circumstances where an error is so fundamental that it will be material even if it didn't deprive the person of a successful outcome. So His Honour said one circumstance might be respect for the dignity of the individual, maybe an extreme case of denial of procedural fairness, or where the decision maker has failed to exercise jurisdiction to decide a question according to the applicable criteria. His Honour also drew a distinction between materiality and futility. And we'll come back to that, the distinction between that a little bit later on. Now, the other case that I wanted to mention is SZMTA, and I'll just mention this very quickly. This was a procedural fairness case, and again, there is a difference between the majority in the High Court and the dissenting judges about the role of materiality in procedural fairness. The majority of the court, Justices Bell, Gabler and Cain, found that even though there'd been a agreed denial of procedural fairness, the document that was in question that wasn't given to the applicant was of such marginal significance that it really couldn't have affected the way in which the applicant presented their case to the decision maker, so there was no denial of procedural fairness. Justices Nettle and Gordon, on the other hand, said that a breach of procedural fairness is by its very nature a jurisdictional error, so you don't need to consider materiality. So there are some differences emerging in the High Court about the role of materiality. I'll now hand over to Deb to talk about some other recent cases.
Thanks, Cain. So the next case that we're going to talk about is a decision also of the High Court, which is called CNY 17. And CNY 17 was a case that dealt with the ground being apprehended bias. And ultimately, the High Court was, the facts of the case involved the provision of certain documents to the Immigration Assessment Authority. And these documents were not considered by anyone to be relevant to the actual protection visa that the applicant had applied for. And in fact, these documents included assertions in relation to the appellant's behaviour while he was in immigration detention, and included statements that he was aggressive and that he'd been involved in a number of different incidents. Now, the High Court unanimously accepted that this information was not relevant to the determination of the protection visa application, but they were split in relation to whether or not apprehended bias was made out, and they were also split in relation to how they actually applied materiality to apprehended bias. So Justice Edelman found that apprehended bias was made out, and he applied materiality to reach this conclusion. And in doing so, he rejected a contention that was made by the appellant that essentially the provision of any potentially prejudicial material would have the effect of apprehended bias being made out. And His Honour referred to the fact that there needs to be some kind of real or practical injustice. So this emphasises the need for appellants to be able to demonstrate that the error has in some way impacted the outcome of the decision. Justices Nettle and Gordon effectively didn't look at whether or not materiality was relevant to this case, because the Minister conceded that if apprehended bias was made out, it would be material to the outcome of the decision. But they did say that the role, if any, of materiality in questions of jurisdictional error and its precise metes and bounds does not arise. So it sort of suggests that their honours continue to take the view that materiality may not necessarily be the most useful principle when looking at whether or not jurisdictional error is established. Chief Justice Keeble and Gabler were in dissent in relation to the substantive issue and considered that no apprehended bias is made out. And they reached this conclusion on the basis that the material that had been provided was so obviously irrelevant to the grant of a protection visa and would have been regarded by a hypothetical, fair-minded lay observer as such. So the test in order to establish apprehended bias wasn't made out. And they seem to say that the presence of apprehended bias in and of itself will be an error that is a jurisdictional error. And so in this case, even if you did apply the test of materiality, you would essentially arrive at the same conclusion. And this seems to be partly because the test for apprehended bias already involves a causal element in that you look to whether or not the apprehended bias could be considered to affect the outcome of the decision. And materiality, as we've discussed, goes to similar issues about causation and the impact of the error on the outcome. So CNY 17 is a good illustration of how courts are really focused on the outcome of the error and the impact that the error has on the decision. And it's also a good decision that demonstrates the split that's happening in the High Court and the difference in terms of how it's being applied. So the last case that we'll look at in depth in relation to materiality is a decision of the full federal court. It's called DNQ 18. And this decision involved a family from Sri Lanka who had made applications for protection visas in Australia. And the key and relevant claim that was advanced by the applicants was that they had left Sri Lanka illegally and feared potential prosecution and laying criminal charges and time in prison if they returned. And these claims were relevantly advanced by the mother and the father and the 3 children as well. But they weren't considered first instance by the authority in depth in relation to the children. And the full court considered that in the reasoning of the authority had overreached in fact finding, and it had actually gone beyond what the material was capable of proving. And this is because the authority had relied on one line in a DFAT country information report to essentially reach the finding that the children wouldn't be prosecuted and wouldn't face time in jail if returned to Sri Lanka. But the High Court considered that that information wasn't enough and that it wasn't open to the authority to reach that decision based on the information that was before it. DNQ 18 is a good decision to look at if you're looking for an example of how the full federal court in particular is applying materiality and how it's trying to tie together the various threads that the High Court kind of put out about how it might apply in any given case. So first of all, they looked to whether or not there was an independent reason that supported the decision of the authority, and then they also looked to whether or not there was a realistic possibility of a different outcome on review had the authority taken a different approach to that information in relation to the chance of children being prosecuted if returned to Sri Lanka. And the full federal court found that there was a realistic possibility that the outcome of the decision would have been different. So now that we've had an opportunity to look through a number of cases that have considered materiality, we've basically tried to pull together a series of points, and we've come up with 8 key points on materiality. The first is that the onus is on the applicant for judicial review to establish that the error is material, and this came from the majority decision in SFMTA. The second is that courts will look to whether there's an independent or other reason that means the decision that's subject to review is still made within the bounds of the decision-making statutory authority. So this is the case in Cain where they accepted that one criteria had not been applied properly and was subject to error, but in any event, the proper application of the other criteria meant that the decision was still within the decision-making statutory power. The third is that courts will look to see whether there's a realistic possibility that had the error not occurred, the outcome would have been different. Fourth, and related to the third point, is that there are frequent statements by the courts that materiality is effectively backwards looking. So you look to see what might have occurred had the error not occurred in the first place and had it not affected the decision. Fifth, courts have maintained the importance of statutory context in determinations about whether or not an error is a material error. So in looking at this question, you have to consider whether the statute says anything about the consequences of the error and how the error could be practically said to affect the decision that was made, having regard to that statutory context. The sixth is that courts have not necessarily adopted a one-size-fits-all test for materiality, and it's apparent that they're applying it differently in each case, and they're applying it differently depending on the kind of error that's being said to be made out of a particular ground of review. And the High Court, the members of the High Court also apply it differently among them. So this is apparent from the way that they've applied materiality to procedural fairness. against apprehended bias, and then also your statutory criterion cases. So one observation that we make about this is that it might potentially make it difficult or confusing for lower courts when they're trying to figure out how to apply this sort of emerging organising principle in circumstances where there doesn't seem to be sort of unanimity in how it should be applied. Seventh, courts have approached questions of fact carefully and have been really careful not to stray into examining the merits of the decision when they're applying the concept of materiality, so keeping that classic distinction between judicial and merits review in mind. And last, there may be times where the application of materiality will not necessarily lead to a different outcome. So it might be that you can apply materiality to see whether an error should be a jurisdictional error. That's the way you characterise the test. But it could be that in applying another principle or the original principle in relation to that error, you would still arrive at the same conclusion. So in terms of talking about how it's changed, how courts are applying, how courts are approaching jurisdictional error, I guess the next question is looking at kind of a comparison. And what we've decided to do is we've decided to compare materiality with the idea of utility, which Cain noted earlier. So materiality, as we've discussed it so far, has been used by courts to determine whether a legal error is a jurisdictional error, and accordingly, whether the error will have the effect of affecting the validity of the decision that's under review. Utility, as it's been applied previously, steps in after a jurisdictional error has been identified, and it's a basis upon which a court might decide to exercise its discretion to refuse relief. And a classic statement that kind of illustrates what futility is about is from that decision of Reala, and it's that the court doesn't act in vain. So a court might find in applying futility that there is an error, and they might even be satisfied that that error is a jurisdictional error, but they might decide that it's not appropriate for them to exercise their discretion to grant relief because it wouldn't change the outcome anyway. Futility looks to the entirety of the decision-making process and has been characterised as being either a backward-looking or a forward-looking test. Classic case that it kind of gives a good example of futility in the way it's applied is the decision in SZBYR. So in this case, the appellants made applications for protection visas in Australia, and these applications were refused. The tribunal upheld the minister's decision and made reference to the inconsistencies between the appellant's oral evidence and his statutory declaration in its decision. But the tribunal ultimately decided to refuse the protection visa on the basis that the applicant's fears of harm stemmed from his relationship with his ex-wife's family and were not related to an actual convention reason. The majority of the High Court relevantly found that even if the appellants in that case had been able to succeed in arguing that they hadn't had an opportunity to respond to the tribunal's concerns about the inconsistent evidence, and it wouldn't have been appropriate to grant relief because it remained the case that the tribunal had refused the applications on the basis that the claims about protection were not in relation to a convention reason. So a grant of relief would not necessarily have changed the outcome of the decision. Another good example of how futility has been applied is the decision in Judicial and the Deputy Commissioner of Taxation. Mr. Juretti disputed the making of a sequestration order on the basis that he had not been afforded procedural fairness. The federal court held that it appeared that Mr. Juretti had actually been afforded procedural fairness, but also acknowledged that notwithstanding this issue, it would be futile to grant relief in circumstances where there were clear bases for making the sequestration order in any event. And the court in Juretti actually looked and considered as to whether or not futility should be backwards-looking or forwards-looking. And applying the backwards-looking test for futility, the court considered that the court below would still have been required to make a sequestration order because the ground of opposition that Mr. Juretti had mounted would not have provided a ground for the order not to have been made. So effectively, it's this idea that even if you did go back in time and change it, there was still another ground that the decision could have stood on. Applying the forward-looking test, the court decided that it would be that even if the decision was remitted, it was apparent that Mr. Giretti was going to run the same argument again, and that it would be a perverse exercise of the court's discretion not to make the order. And so it basically reached the conclusion that, applying futility, whether you look backwards or whether you look forwards, in Mr. Giretti's case, it simply wasn't going to affect the outcome, even if relief was granted. So you do see some similarities in the outcomes of the decisions and how they're applied in relation to materiality and to futility. For materiality, the courts are essentially satisfied that an error has occurred, but have to decide what effect the error has on the legal correctness of the decision, and whether the error has the effect of meaning that the decision maker was beyond power in what they did. For futility, courts are satisfied that a legal error has affected the correctness of the decision, but they go on to then consider what effect, if any, the grant of relief could have. And if a grant of relief could not affect the outcome, then the court may decide to refuse to grant relief on that basis. So a comparison between these ideas and how they've developed gives us a bit more insight into how courts are grappling with this idea of how you can measure an error and how bad it really is. But both materiality and futility are useful tools that have assisted courts in identifying when it might be appropriate to intervene.
Thanks. I should have said at the beginning, and I'm sorry I didn't, that there's the opportunity to ask questions through the app, and I think we've had a couple already. If you have some questions, please do send them through, because we've allowed a bit of time at the end for some questions. I suppose by way of sort of wrapping up and summary, there is a possibility that materiality could be an organising principle for jurisdictional error if the courts were to consistently apply materiality as the touchstone of whether or not an error is jurisdictional. Then it might go some way to relieving jurisdictional error from its label of being slippery or conclusory, because it would really be giving some concept, some sort of meat to the concept of jurisdictional error, rather than just being a label applied at the end of the day when a court has decided that an error is sufficiently serious to warrant judicial intervention. The difficulty, I think, at the moment is that there's not a consensus amongst a majority of the judges in the High Court about how materiality is to be applied. So some judges equate materiality with jurisdictional errors. Others say that an error might be jurisdictional error even if it's immaterial. And so what we think is that the present state of the law is likely to result in some confusion, particularly for lower courts for a little while yet, about whether or not, or rather how, to apply materiality in the analysis of whether or not an error is jurisdictional. Now, in some ways, this is sort of continuity with change. It's the way that courts have always been developing judicial review principles. Things come in and out of vogue. Jurisdictional error has only really been around since as a really significant issue since the High Court's decision in Plaintiff S157. So it's possible that materiality might just be a fad, and over time it'll be reduced in the way other concepts in judicial review have become into something that's applied on the facts of the case and on the statute in question, and really won't give rise to any sort of great organising principle. I suppose, practically speaking, two issues might arise. The first is, how does materiality affect how courts and litigants in judicial review proceedings conduct judicial review litigation. And the second is, how does it affect decision makers in terms of how decision makers should go about making decisions, or indeed how in-house lawyers should go about advising decision makers either before or after a decision has been made. Looking to the first issue, our view is that materiality probably really isn't likely to have a huge amount of impact on the way in which judicial review litigation is conducted. An applicant in judicial review proceedings almost always will try and argue that the outcome would have been different had the error not occurred, and so it shouldn't be too much more work on the part of an applicant to address the question of materiality. As Deb mentioned, it's something that's on the it's the burden of the applicant to demonstrate that the error would have made a difference. On the other hand, though, it does provide a useful defence to judicial review challenges where an error has obviously occurred, but the error is insignificant to the outcome. A number of the cases that we've talked about today are where there has been a concession that the decision maker made an error in the decision-making process, but nevertheless, that error shouldn't be regarded as being jurisdictional because it wasn't material. So in that respect, it may be a useful line of defence for decision makers in defending judicial review litigation. And it's likely to be slightly more useful than futility as being a reason to withhold relief, because futility goes to discretion. And our analysis is really that the circumstances in which a court might find that there has been an error, but nevertheless the court should decline to grant relief are really very small. And so the number of cases where that has occurred as an overall proportion of cases where there's been an error is very small. And what does it mean for decision makers? Well, probably not a great deal, to be honest. There's the thing with materiality is it's something that is important, if and only if an error has been identified. So the decision makers obviously can avoid the issue altogether if there is no error. But once there is an error in the decision-making process, then it's really going to be up to the court to decide whether or not that could have made an outcome, and there isn't really a great deal that decision makers can do about that. One thing that's been mentioned to us is that should this mean that decision makers base their decisions on alternate grounds? So you might say they will refuse some application on this ground, and also this ground, and also this ground, and also this ground, so that you, even if there's an error in one of them, or there might be a procedural fairness defect in relation to one of the grounds, it might be upheld on the basis that the rest of it stood. My view, for what it's worth, about that is that that's not a particularly desirable way of expressing administrative decisions. I think the experience is that courts are far more forgiving of decisions where there's only, one or two really strong grounds for forming a view, and much less forgiving where there's a couple of good grounds but a whole lot of other things are thrown in for good measure. That tends to undermine the significance of the good grounds. So ultimately, we think that it's not going to make a great deal of difference for decision makers, but it might give litigants on the side of government decision makers a bit more of an opportunity to argue that even if there was an error, it wasn't material to the outcome. So ultimately, what decision makers need to do to make robust and defensible decisions has not changed greatly as a result of this. We're now probably in a position where we can take some questions. So one of the questions that we've been asked is whether materiality is the same sort of concept as mandatory or directory. So sort of a Project Blue Sky kind of analysis about whether or not the Parliament intends that an error should give rise to invalidity of the decision. It's a good question, and I think some of the decisions in the courts are quite focused on materiality being derived from the statutory context. So they sort of say what's going to be material will depend on the statutory context. Other decisions, it seems to be almost divorced from the statutory context. So, where it's not really an issue about the statutory context, it's just simply did the error make a difference to the outcome. So I think the answer to that question is that it probably is yet to be seen how that applies. Yeah. Another question is how would these concepts apply to decisions made by IT systems, so where you've got sort of algorithmic type decision-making functions. Deb, do you want to answer that one? I'm happy to go with you.
I mean, I guess it's probably another situation where it depends on a case-by-case basis, but that might be one where you're really looking to the kind of practical impact of the error that's in question. And I guess it also depends on how the decision making has occurred. I guess I have to say I don't know enough about how robodebt or kind of IT type, decision making happens, and the reasons that are given in any given case will probably make a pretty big difference to that.
Yeah, look, I mean, I think that the errors in if there are errors in computerized decision making, materiality will apply in much the same way as it would as if it were a human decision maker. I mean, I think that the state of the law in relation to computerized decision making is that basically what needs to be shown is a reasoned process. I don't think the courts need to look inside they don't need to understand the code of how the decision is made in a sort of a technical sense, but they need to see the computer needs to behave and produce a statement of reasons as if it were a human producing a statement of reasons. And so I suspect materiality will apply in a very similar in a very similar kind of way. I suppose with computerized decision making, it's possible that unintended errors might be amplified due to the number of decisions being made. So it's possible that the kind of material effect might be perceived as being greater because there's a larger number of decisions being made on some erroneous ground. We've got another question about how materiality gels with rule of law principles and whether it's acceptable that materiality might be interpreted by decision makers that you can make legal errors and it doesn't really matter if they don't make a difference to the outcome of the decision. For my own part, I think there's always been a bit of an issue in the law about the role of jurisdictional error and the idea that the decision maker can make an error in the decision making process, but that error won't go to the decision maker's authority. This is, sort of probably very unpopular view to have, but I don't think that's a particularly, I don't think that sits particularly well from a theoretical point of view. I can understand the point in relation to jurisdictional error having a role when you're talking about reviewing a decision of a court, for example, where the court will be seized of jurisdiction and within its jurisdiction it can make errors. I think that makes sense to me as a concept. It doesn't really make sense to me that Parliament would give an administrative decision maker scope to make an error. It seems more logical to me that the way you've described that is that Parliament's saying it's not an error. So I think there's always that tension in terms of rule of law in judicial review generally, that not all errors are going to be actionable in judicial review. And obviously, you can never predict how a court is going to treat an error. So my decision makers, would be very cautious about saying we'll be a bit blasé, for example, with this legal criterion because we'll have a crack at materiality if it gets before a court.
Yeah, that's right. I think that there's also kind of been a real conscious attempt by courts that are dealing with this idea of grappling with the concept of materiality, that not to create a hierarchy of errors. And I think it's important in that to remember what Cain said at the beginning of the presentation, which is that jurisdictional error is one tool that courts have developed to identify, a decision that might not be robust in some way. So it seems that they can sort of do that, and they don't necessarily think that it's the case that an approach to decision making that relied on more minor errors being made and then not being considered to be errors in the jurisdictional would really succeed, and you would obviously still have to go through the process of being subject to judicial review.
Okay, well, I think we don't have any further questions. So we'd like to thank everyone for logging in today and for joining us in this CLE. We're sorry that we can't have our usual drinks and canapes afterwards, but hopefully we'll be able to return to that mode of operation in the not too distant future. We will send out an email after the presentation today in which we'll give you the paper from today, and also we'll address any other questions that might have arisen which we haven't answered during the presentation. As I mentioned at the beginning, we do have more webinars scheduled in the coming months, and if you'd like to be included in our mailing list for those sessions, please do get in touch with us. Thank you very much again.